the party of democracy and the party who spent the last 4 years gloating with a sort of moral superiority about how Trump refused to accept the results of an election are, unsurprisingly, still refusing to accept the results of an election less than a month before Trump's inauguration. Hello everyone, and welcome back to the channel. It's not at all a surprise that the left is still grasping at straws to try and stop Trump from taking office. A new piece came out in The Hill the day after Christmas, written by a couple of lawyers who laid out the exact legal path to cinching the election for Kamala, including a tactic that sounds eerily familiar. Now, of course, there are some lawmakers denouncing this plan, but there are some folks out there that think that this is a wonderful and very good idea. But before I get into their exact proposal that they say can only work if lawmakers do it right now, this video is brought to you by Blackout Coffee Company, the Florida coffee roaster that supports your Second Amendment rights, your favorite gun rights groups, and channels like mine. Blackout is the perfect thing to help you with your post-holiday recovery, keeping you awake, not woke. So to help support the channel and your rights, go to blackoutcoffee.com/libertydoll, and if you haven't already, use code LibertyDoll for a one-time 20% discount. To start, the reasoning behind these lawyers' position is the same one that we've heard for 4 years. The Constitution provides that an oath-breaking insurrectionist is ineligible to be president. This is the plain wording of Section 3 of the 14th Amendment to the Constitution. No person shall hold any office, civil or military, under the United States or under any state, who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. This disability can be removed by a 2/3 vote in each house. They argue that the basis of this clause is that Trump tried to overturn the Constitution and not the government. They say that at Trump's impeachment trial in early 2021, the vote to remove him from office was narrowly missed, but the message about his engaging in insurrection was clear and decided. They say that this is proof positive number 1 that he fits the bill for Section 3. They neglect to mention that while the House brought the accusation, the Senate acquitted him, which by definition makes him not guilty. Never mind that he was never actually charged with insurrection, let alone convicted. They also say that the Colorado Supreme Court found him guilty of the same, even though again, he's never been formally charged and convicted, but lacked the power to invoke Section 3. Upon appeal, the U.S. Supreme Court did not address the insurrection claim. The lawyers neglect to mention, again, that the Supreme Court said that Congress must pass a law to make this happen, and Congress didn't. Finally, the lawyers point to the congressional investigation, citing specifically that Trump asked Pence to throw out the Electoral College. Remember that in a moment. Now, these 3 things, they say, make it clear that there is a case to block Trump. In fact, there is a duty to block Trump, and that stopping him from taking office is a moral imperative. Democracy is at stake. Then they go on to suggest the lawmakers do it by throwing out the Electoral College and refusing to count those votes on January 6th. Gee, I wonder what happened the last time someone suggested that. But they say that when the left does it, it will be different, because it will be a few members of Congress gunking up the works rather than the current president, and since the Constitution makes Congress responsible for certifying the election, it allows them to also throw out democracy without a guilty conscience, even though Trump also won the popular vote. They also say that the Supreme Court's own argument in this case disqualifies them from having any voice in the matter. Finally, they point to an 1887 law that was, coincidentally, amended in 2022 called the Electoral Count Act. The act specifies 2 grounds for objection to an electoral vote: if the electors from a state were not lawfully certified, or if the vote of one or more electors was not regularly given. A vote for a candidate disqualified by the Constitution is plainly in accordance with the normal use of words not regularly given. Disqualification for engaging in insurrection is no different from disqualification based on other constitutional requirements such as age, citizenship from birth, and 14 years residency in the United States. To make an objection under the Count Act requires a petition signed by 20% of the members of each house. If the objection is sustained by the majority vote in each house, the vote is not counted and the number of votes required to be elected is reduced by the number of disqualified votes. If all votes for Trump were not counted, Kamala Harris would be elected president. So again, their suggestion and proposed plan is to have Congress whip up a petition to not count the votes for Trump and only count Kamala's votes, which is far more sinister than asking to wait until election and voting irregularities are investigated and figured out. Now, these lawyers argue that due to the number of Republicans in Congress, this is unlikely to work without some heavy lifting from Democrats. But they say it is their constitutional duty to try. Because, they suddenly care about the Constitution. It also should be noted that U.S. Assistant Attorney General Jeffrey Clark was politically persecuted for drafting a memo in 2020 proposing a very similar legal challenge. Whether you love Trump or hate him or somewhere in between, you can't deny that the state has been bending over backwards to fight him for about 10 years now, and that alone should tell us a lot. As for the 2 lawyers behind this piece, well, they don't explicitly tell us their political leanings, but they don't really need to. I think we can guess. The content of their argument is enough. But in case any doubt was left, one of them previously represented Mario Cuomo, former governor of New York, and was a Democrat candidate for New York Attorney General in the 1990s. The other is a dear friend and supporter of Barack Obama and the Clintons, and even allegedly rented out his Martha's Vineyard home to the Obamas. So, no bias there at all. Alright gang, that is it for this video. You guys know the drill for all of the all-grown things. Again, I hope that you had a good Christmas and a good New Year. I don't even know what date it is, so I don't know how many days we have until New Year's. I'll probably have another video out before then. I don't know, man. Space and time does weird things when you're sick, and holidays and all that. Anyways, thank you everyone for tuning in. Stay safe out there and happy shooting.